Today we get to talk about a topic, the oil and gas lease, that we'll talk about for several classes over the remainder of this course. And it's exciting because the oil and gas lease is one of the most revolutionary legal documents that has ever been created in terms of its impact on the world. The oil and gas lease is what determines the usual relationship in the United States between a landowner and between the oil and gas company that extracts that landowner's oil and how much that landowner receives. And the reason I say it's so important is because, as we know, oil and gas is the key to the modern world. It's why we're able to travel around the world. It's why we have our modern technology. It's why we have all the manufactured products that we depend upon. And so the ability to extract oil and gas is key, but we often think about how difficult it is to extract those resources. And certainly in the United States, we are lucky that we have a lot of those resources. But the US doesn't even necessarily have the best oil and gas resources. The reason that it has dominated world oil production and made the US the world's sole superpower for such a long stretch of time is because we came up with the legal documents that were later used as models around the world for oil extraction. And the simple oil and gas lease developed here can fit on a page. I uploaded a example lease for you, is used as the basis for oil extraction around the world. So it may have been developed by farmers here in Texas working with small oil companies, but versions of this lease are still used today by the biggest oil companies in the world, by the nations that have the biggest amount of oil wealth. They use this same simple document to share the revenue between the producing oil company and the landowner who owns those resources, whether it's the state or a private landowner. And so in many ways, the modern world was enabled by the oil and gas lease. So for those of you who've taken business enterprises, you may be aware that the president of Columbia University at one point said that he thought the limited liability corporation was history's most important legal invention. But I have to say, I'm sorry, I think the oil and gas lease, if you look at its impact on humanity, no document has been more important. So let's talk about that oil and gas lease. Now, the first thing to understand is we often talk about what an oil and gas lease is and what it says, but there is no standard oil and gas lease. So every oil company may use its own kind of form lease that is the kind of lease it likes to sign. But another oil company will use a different form, and there have been other forms, i.e., basic styles for leases that have grown in popularity and been used at various times. On the website, I've given you one of the most common forms of all time, which is called the Producers 88 form. It is a form that is designed to be in the oil company interest, so a lot of oil companies would use it, but of course there are other forms that would potentially benefit landowners more. There's thousands of these different forms. Usually they're drafted by the lessees, by the oil companies, right? The oil companies are typically the more sophisticated party. Usually they are the ones drafting the forms, and they give a form to the landowner and allow them to customize a few terms. Now, you can find some landowner-focused forms. So landowner, lessor focused forms. If you were looking for those, you could look at bank trusts. So if a bank holds property in trust, it has to ensure maximum profits from the oil and gas on that land. And so it has forms that it uses when it leases that land to oil companies for development to ensure that it gets the biggest share of the oil and gas wealth on that land. So you can look to those bank trust forms. Also, sometimes landowners associations will have standard forms that they use. And so if you were a private landowner looking to lease your land and you said, where can I go for ideas? You could go for forms to those two groups, bank trusts, landowners associations. Now, because normally these forms are drafted by oil and gas companies, they give you the form and say, okay, what do you want to change? Typically, they are aimed at protecting those lessees, those oil and gas companies. Now, what does that mean? That means the oil and gas companies are looking to have the exclusive option to produce oil and gas from land, but they don't want to be obliged or forced to drill or spend a certain amount of money on land. So they want to be able to drill whenever they want and be able to keep their share of oil as long as there's oil to be had on that land. But they don't want to have an obligation to drill in a certain period of time. Now, of course, any lease has two parties, and so they don't get everything that they want, but that's what they're looking for. Now, because typically those oil and gas company lessees are the ones that provide the form, and typically they're the more sophisticated party, courts tend to interpret those leases against the oil and gas company. And so if there's an ambiguity, they're usually going to resolve it against the oil and gas company. And what we'll see is sometimes the courts go even beyond ambiguities, and they'll imply terms that aren't even in the contract. So you may be used to courts basically trying to follow the text of contracts. That happens a lot of times in your contract classes. But what I'm going to tell you here is sometimes in oil and gas, the courts, especially in the past, would more or less make up terms to try and make the oil and gas lease fair to the landowner. There are also often implied covenants. So often the courts will interpret a lease to imply certain duties on the oil and gas company, and we'll talk about what kind of duty those are. So the basic problem that you have when you're a landowner and you want to develop the oil and gas on your land is, for most landowners, you don't have the workforce, you don't have the equipment, you don't have the expertise to develop your own oil. Almost no one does. So you need to bring in an oil and gas company to produce your oil. Now the problem is that oil and gas company is going to have to spend a lot of money to extract your oil and gas. If all goes well, they should get a lot of oil and gas and all their costs will be paid back. But they're going to have a lot of costs. They're going to have to give you a share of the production. That's what you're negotiating for as part of your lease. So they're going to have to pay your royalty, of course. They're also going to have to pay, rent and fees on their equipment. They'll have permit fees, etc. There are a lot of costs that they're going to face. They're going to have to pay taxes on their production and on their profits. They are going to have operating costs to actually operate that well. And of course, they're going to have a huge capital investment in that well where they've invested in all the drilling, nowadays fracking, etc., that makes oil production possible. And once they take all the oil and gas, they give you your share as a royalty, they pay all these costs, they need to get their expected return on investment. And how high does that expected return on investment need to be? Well, pretty high. So let's look at a completely different kind of company. Also an energy company, but one with very low risk. Imagine an electric utility in a state where everybody has to purchase from that utility. That utility can pretty much be guaranteed, unless it does something really negligent or something goes wrong, to recover the cost of its investments, because it's allowed to charge a rate to recover those costs. What kind of return on its investment is it looking for? Remember that if it doesn't do anything wrong, it's mostly a sure thing. Well, it's going to often get a return on investment of, say, 8 to 10%. Maybe if it's something really hard that it's doing, hard to get the permits, et cetera, might get 15%, 16%, 17%. Okay? So let's just say, round number, 10%. So if you have this relatively low risk investment, you want a 10% return to make it. Because if you're not getting a return, you might as well invest your money in the stock market, make 5%, 6%, 7% return on your investment. So generally, companies making investments are looking for a significant return, much bigger than that kind of safe return of a utility of 10%. They are looking for 15, 20%. Now, if you're an oil and gas company, you're making a very risky investment because you're investing all this money up front. But as we know, a lot of the time you drill a well and there's no oil and gas. In fact, that's the norm for most of history, is that the majority of wells you drill, you're getting nothing back. So on those wells that you hit, you need to make a good profit because you're taking a big risk and you have lots of other wells where all your costs you have to just write off. So companies need to make a significant return on investment because they're investing a lot of capital and taking big risks. So as a landowner, you want this oil and gas company to come produce your oil and gas, but the problem is you're going to have to make sure that you give them enough oil and gas to pay all their costs and to give them a big enough return on investment to justify those risks. So, how could you structure the payment to the landowner? Well, if you wanted to put it in very simple terms, what you'd want is the economic rent from the oil and gas that's under your land. Now, the economic rent is basically the surplus that's left over if you take all the value of the oil and gas, subtract the cost of producing it, and a normal profit. So the economic rent is everything, the value that you have in that resource that goes beyond the cost to extract it and a normal profit. So let's imagine that we have $66 million of oil production on Laura's land. This is the example that I gave in my article on the third age of oil and gas law. Imagine that we had a pretty good idea there were $66 million of oil under the ground. And let's imagine that we thought it'll cost $40 million to extract it. Well, let's say that we thought a normal profit for an oil company would be $6 million on its $40 million expense. Okay? Now, what Laura could say is, hey, give me the rest of the economic rent. I'll give you your normal profit, but I want to have all of the economic rent. So you can have your $40 million in cost back, you can have $6 million in profit, but give me the $20 million in economic rent. I want that lump sum. I can promise you no oil company would agree to that. Because look at it from the oil company's perspective. How much money are they laying out? Well, they're giving $20 million to Laura up front, and they're paying $40 million in costs. So they really have $60 million that they're laying out. What profit are they getting? Well, they're getting $6 million. So they're just getting a 10% profit. Remember, that's what the safest companies get. And the problem here is the oil company doesn't really know that all these numbers are exactly right. So it's taking a huge risk. There's $66 million of oil, they think, but it could be substantially less. And the cost to extract it would be $40 million, but that could be less. As they know, the costs of all the things that they need in terms of labor or a drilling rig could be bid up. Or the cost of oil could go down, and what was worth $66 million a year ago could be worth $33 million now. So that's simply too risky for the oil company. I want you to notice that it's also really risky for Laura, because end of the day, Laura gets $20 million. But what if the oil price doubles next year? Does Laura get any more money? No. In fact, in that case, the oil company does really well. So for both parties, this transaction where you just have a lump sum payment is pretty risky because it leaves them both exposed to the uncertainties of future oil prices and what the costs are going to be. So let's look at the way things are handled under a normal lease and how that divides the risk between the parties. Under a lease, as I've said before, and we'll talk more about today, the normal way that the landowner gets money is with a royalty. And a royalty is just a share of production. So I've calculated a royalty for Laura that's just designed to give us even numbers, which is if we have $66 million in the ground, let's say that Laura gets a 27.3% royalty that, if all goes according to plan, will give her $18 million. Now, Ovid's costs, again, are expected to be 40, and so $40 million, and so Ovid's profit would be $8 million. So Laura's being a little bit more realistic here. Ovid is looking for a profit on its expenditure of $40 million of $8 million. So it's getting a 20% profit. It's a little bit more realistic. Note that it doesn't have to make any upfront payment to Laura in this circumstance. And so in a couple ways, this has massively reduced the risk for Ovid. There's no upfront payment to Laura. So if for some reason this well doesn't produce any oil, which as we know is always a possibility, then Ovid doesn't have to pay Laura anything. So you've massively reduced your risk in terms of what happens if it's a dry well. Also reduced your risk if it only produces half the oil you were expecting. Well, that means the Laura share will be half as big, and so Ovid will get to, so Ovid won't be on the hook for such a big payment to Laura. On the flip side, it also reduces risk to Laura, because remember, we said the risk to Laura was, what if there's actually $120 million of oil production? Well, here, she gets a constant share. So if there's more production, she gets to keep it. And remember, that can be very important to landowners, because if you've sold your mineral interest instead of leasing it, you just sold it to somebody else and for a lump sum, it's really annoying when there's a lot of oil on your land, because you've already got all the money you're going to get. And they're going to keep drilling more and more. So there's going to be more and more hassle of oil and gas drilling to deal with. But if you have a royalty, a share of production, then every time you see a new well go in, that's great news, because you're getting a share of that production, and that's more for you. And we'll see in future classes how that can reduce conflict between the oil and gas company and the landowner. All right. So if this is the typical lease, how does this work? And I've given you, again, that Producers 88 example. We'll go through it a little bit more, but let's start with what are the basic parts of a stereotypical Texas lease. And this would also be a lease that you would see in the other states around the US. So normally, the oil and gas company, the lessee, is going to get an exclusive right to produce oil and gas for some number of years. So stereotypically, let's say for 5 years. And then it gets to keep the lease for as long thereafter as oil or gas is produced. So basically it gets some number of years, say 3 or 5, sometimes as much as 10, it gets some number of years to look for oil and find oil. And if it produces oil, then it gets to keep that lease as long as oil and gas is produced. Now, the lessor, the landowner, is going to get two kinds of compensation. They're going to get some bonus up front. That'll be some money. But the biggest amount of money they get is going to be from a royalty, a fraction of production that's going to pay them much more money over time. So that's where the principal compensation comes. So if it turns out that there's no oil on your property, you still get the bonus. And that's some money, and it's great. You could go buy yourself a pool or a motorcycle. But the royalty is where you're going to get rich. If they hit oil, you can get a lot of money from that. So that's where the primary compensation comes in. All right. So we need to modify that previous chart I showed you of Laura's deal with Ovid Oil Company to consider that bonus as well. And I want you to think about why the bonus makes sense from the perspective of the landowner. The basic reason is that, remember, the lease gives an exclusive right to produce oil and gas for a certain amount of time, maybe as much as 5 or 10 years. The oil company needs to know it's got some time to go find oil and gas. And that may take a while. It may need to explore. It may need to get the equipment together. It's going to need to drill and find oil. Now, while that first, what we call primary term is playing out, where the oil and gas company is looking for oil, Laura cannot lease her property to anybody else. Her property is entirely held up. But she's also not receiving any royalties until the oil and gas starts being produced, because she's paid a share of production, and if there's no production, she gets no royalty. So typically, landowners need to be compensated to agree to a lease because you're taking your property off the market for a while. So imagine this circumstance. Laura says, you know what? You need to pay me something to lock up my property for 5 years. Pay me a $1.5 million bonus. I want some of the money up front, but I'll take the bulk of my money as a royalty. So if all goes according to plan and you produce this $66 million of oil, I'll get $16.5 million from my 25% royalty. But either way, whether you find oil or not, you're tying up my land for 5 years. I want a bonus, and you're going to get me $1.5 million. Note that as a landowner, if the oil company won't give you any bonus, that might be a sign that they're not really serious about producing your land. Because if they give you a 0 bonus or a very low bonus, what does the oil company have to lose by agreeing to a lease with you? You just agreed to give them the exclusive right to produce for several years, maybe 5 years, maybe 10 years. And they don't have to pay you anything unless they happen to find oil and gas. If it costs them nothing and only comes into play if they happen to find oil and gas, why not take leases all over the place, more leases than you could possibly drill, because it's just your own option with no obligation to drill. So a bonus is what kind of keeps the company honest. If they're willing to give you $1.5 million, whether or not they find oil, they're probably pretty certain that they're going to try drilling there. They're taking this seriously. They really think there's oil on your land, and they're going to look for it. All right, so what are the essential parts of the lease? And we're going to be talking about these over the coming weeks. One, what land and what minerals are included in the lease? You know, is it your whole plot, or have you already leased part of it to somebody else? Or is it every layer of depth, or is some part of some reservoirs deep down or near the surface already leased to someone else? And what minerals are included? Does it include if we find something like uranium or coal? Also, How much money to the lessor? That's typically the main item of negotiation. How big will that bonus be that we get up front? And then how big will the royalty be? In the producer's 88 form that I gave you, you can see that those parts are left blank in all the forms. That's something that the parties have to negotiate. There are other small amounts of money that the lessor, landowner, will receive, like delay rentals and shut-in royalties. Those can present complicated problems, but usually they're not really the bulk of compensation under a successful oil and gas lease. Another important term to consider is how long is that primary term? How long does the company have to drill to find oil? Is it going to be 2 years, 3 years, 5 years, 10 years? And are there things that they can do to extend the primary term if they don't find oil right away? Another very important consideration that we'll talk about is, let's say that you have a 500-acre property, so it's really big, but the company just drills a well in one location in a corner of that property. Will that one well be enough to keep the lease active with respect to the whole property? Remember, the normal lease operates as long as oil and gas is produced. Or do you want to say, no, you just keep that little part where you're producing? That's an important consideration that landowners now have to think about. Finally, how will royalties be calculated? This turns out to be quite complicated with respect to natural gas. With oil, pretty easy. There's a price for oil. It's relatively easy to determine. But remember, natural gas is hard to sell, and sometimes the company will have to build pipelines and send it far away to find a place where it can be used. And sometimes the oil company will have to spend money to take that natural gas and make it marketable so that somebody will want to purchase it. Should the oil company be able to deduct all those costs? Should they pay you the price that they got far away after they spent a lot of money to transport and purify that natural gas? Or should they pay you what it was worth at the well? Turns out to be a very important question, and a question that has caused a lot of litigation. So what is the lease really? You know, it's in some ways a conveyance of property, that is a transfer of property, but in other ways it's a contract. It's probably more like a deed than your typical residential lease. It's not, in some ways it is transferring the right to the minerals, or to a share of the minerals in the land. So it includes a right to take the substances as well, to take away that oil and gas, as well as use the land. And the lessee's rights are potentially perpetual. So it's that oil and gas company usually can keep operating as long as oil and gas is produced. That's very different from a residential lease that you sign for an apartment where you're out of there after a year or 6 months. States can classify them differently. In Texas, and this a lot of times breaks down along those lines of ownership versus non-ownership states. So in Texas, it's a fee simple determinable. And in Oklahoma, it's a profit apprend, as we talked about, the exclusive right to produce, but it has equitable termination. In a lot of states, they haven't even decided where they fit along this spectrum. So what are the essential clauses? And as I talk about these, might be helpful to follow along with that producer's 88 lease and look at where these clauses are located. I'll reference them by paragraph. The granting clause, that's the first clause, and that tells you what kind of land you're talking about and what kind of substances. It tells you those important questions. The habendum clause, that's a word you'll have to get used to. Habendum clause tells you how long the oil and gas company gets to keep that land. How long does it have to drill for oil? And if it successfully finds oil, how long does it get to keep it thereafter? Drilling delay rental clause. Paragraph 5, this allows the oil and gas company to pay a little money to keep that primary term going till its natural end. There are savings clauses. These are clauses that say, well, even if you're not technically producing all the time, you don't technically get your well finished before the end of the primary term, or during your secondary term, oil and gas production stops for a little bit, you still get to keep the lease if you meet one of these savings clauses. So in paragraph 6, you can see a dry hole cessation of production clause that basically says, look, the first well we drilled was dry, but we're working on it, and so we should be allowed to keep the lease. You can have pooling or unitization clauses that say, yeah, I didn't drill a well on your land, but I pooled you in with some neighboring land, and you're getting oil from that neighboring land, so it's effectively like I drilled on your land, and therefore I should get to keep this lease. A shut-in royalty, we've already talked about that. Paragraph 3, that's what happens when you find a gas well, but there's no market for that natural gas yet. And so you shut it in and pay a little royalty to keep that lease going. Force majeure. Force majeure is something unexpected happened that prevented us from complying with this lease. There was a hurricane. There was an act of God of some kind. There was an unexpected change in government regulations or otherwise. Force majeure is here at paragraph 11, and we'll see there can be lots of debate and litigation about whether the oil and gas company really should have been able to anticipate this problem arising.